All right. What's up, guys? Welcome to another episode of Brand Builder TV, where we want to share with you real world content on how to brand and market in 2020 versus 2004. And as you always hear me say, there's a big difference. The evolution train is leaving with or without you. The question is, are you going to get on or is it going to run you over? And I want to talk, I'm excited about this episode tonight because, first of all, our guest, Tom Ladegaard, I've known him for a few years. He actually was on Monster Motivator TV, and I use him as, I hire him as multiple times throughout the years to protect my names and give me a lot of great legal advice when it comes to trademarking and protecting your babies. Really, ultimately, that's what it comes down to. So I'm excited. His firm is blowing up, and we wanted to get him on. As you can see, he's burning the midnight candle. Can't get yourself out of there, huh?
I'm stuck here right now.
That's it. So without any further ado, Tom, I'm going to hand it over to you. Give us a little 30,000-foot view, right?
Okay.
Who you are, where you came from, and what's going on now, and then we're going to chunk that down and talk about branding and marketing and things that you want to protect. You guys are going to leave here with real practical steps and real practical advice on branding and marketing 2020.
My name is Tom Ladegaard. I'm an attorney in my 16th year of practice, and I've got an office in Carlsbad, California. For 14 years of my career, I was a litigator where all I did was represent parties in court, state court, federal court, all kinds of businesses, and got great experience in the courtroom. Almost 3 years ago, I went solo. I left the law firm I was working at downtown, and I went out on my own, and I had one client. So I went out on my own. I had a side business, a videography business I was doing at the same time, and found that it was too overwhelming to run two businesses at the same time. So I decided to consolidate my efforts, and I'm focused right now on my law practice. And in the couple of years since I've gone solo, I've diversified my practice. I'm doing transactional work as well. So I'm doing entity formations, I'm writing contracts. And then what I'm really excited about lately is I've been doing intellectual property. So I'm doing trademark filings and copyright registrations. And that's an area of the law that I'm really enjoying. Because I have a litigation background, I can see the future. When I'm dealing with a client situation, I know how this scenario can play out in court because I've fought these things in court. So I believe that having a litigation background really makes me well suited to help businesses protect themselves as we're planning and doing the formation. So tonight we're here to talk about intellectual property, specifically trademark, because it's a critical part of the branding process. So when businesses are setting up and they're considering what kind of name they want to go with or product or service name they want to go with, trademark is something that a lot of businesses unfortunately overlook, and that can turn around and bite them a couple of years down the road.
Yeah, and give us a little idea of some of the different clients that you work with to give people some perspective.
In the trademark context or in general?
Well, trademark, because
Okay.
it's gonna really map the branding, right? And how important. Look, if you're building your brand, business or personal, you got to be protected, or at least get educated on that process.
I just tallied it up the other day. I've got 18 trademark applications pending with the USPTO right now, with more in the pipeline. So I'm getting ready to file one on behalf of an app developer.
Okay.
I've got 4 or 5 marks pending right now for a life/business coach.
So what would that, give us some examples. You don't have to use names, but give us some examples of what you're doing for them and why it's so important. Life coach, because, again, there's so many out there.
So there's a trademark for her name. So she's got a corporate name, which is also her trade name. That is trademarked.
Okay.
But she's got these individual modules for these packages that she provides. Each package has a different name, a distinctive name. And so we're applying for trademark registration for each of the names of her different services.
Okay.
And so for you, for example, we got a trademark for DDMM Nutrition, which is your umbrella brand name. That's trademarked. But we could separately trademark each of your products. So Roar or Knocked Out or any of your other supplements can separately have their own trademark as well.
Okay.
So to continue with other examples, I've got one pending right now for someone who does end-of-life planning. So I'm doing a trademark for her business name. I've got another one pending I got several pending. I've got a client who manufactures dentures, and I've got several trademarks pending for him, including I got 2 marks put through the system for scents. So he's got these wax compounds that become dentures, and a scent emits as they're getting milled. We trademarked the scent, and there's only been like a dozen of those in the history of the United States that have gotten through. We got 2 of them.
What's the advantage to the scent? Like why? What is that?
The scent is part of his branding.
Okay.
So people associate the smell of the product with his brand.
Got you.
Yeah.
Okay.
It's really narrow circumstances where you can actually get that to fly. And the examining attorney I was working with at the USPTO, she told me on the phone, she's like, I've never seen one of these before. And I said, neither have I. And so we both kind of figured it out together. We kind of partnered up. It was kind of cool. What else do I have pending? I've got one pending right now for a divorce coach. She coaches women going through the divorce process.
Okay. So she's protecting her name?
The name of her brand, her business, yes.
Okay.
So her corporate name is different from her trade name. So she's got like a generic sounding LLC, but the trade name that she does business with to the public.
That's who the public knows.
Correct.
Right. I got you.
So we're getting one for that. I've got one right now that's about to get pushed through for an office furniture installing company. So they're a general contractor, and they'll come to an office building and they'll deck out the place with office furniture. I've got a mark pending for them. Gosh, what else do I have pending? I wish I had my whiteboard right now so I could see my whole list.
So take us through the process when somebody calls you and says, "Hey, Tom, I have this business, or I'm ready to launch this business, or I've had this business and I never thought about trademark. I saw you on a podcast." Walk us through that.
The first thing I'm going to do when someone tells me the name of their business, their product, or their service, the first thing I'm going to do is I'm going to go on to the official trademark database. It's called TESS, Trademark Electronic Search System, TESS. I'm going to look it up and see if the name is available. I can do it on my phone. I just do it on a web browser. So I just do it in real time when I'm talking to people just to see if it's even available. Now, you don't want to just run a quick search and say yes or no. There's more analysis required. But if someone wants me to trademark their name, the very first thing I'm going to do is just look it up and see if it's available.
Okay.
Another thing I'm going to do is analyze the name. Like, is the name generic? Is it descriptive? Or is it distinctive? Because if the name is generic, or if it just describes your service, like Paul's Painting Company, it's never going to get through. Okay. So I'll tell you, don't even think about trademark, or maybe get a new name. So it has to be distinctive. So that's the thing. Is it available, and is it trademarkable? Those are the things I'm thinking of initially.
Right out of the gate. Yes. And I know, working with you on some different things myself, the great thing that you bring to the table, the value, is explaining, okay, we're here now here are the categories, right? And here let's figure out what I liked is you helped me figure out what's really priority, right? Because all of a sudden as a layman, I'm like, what? Where do we even start? Where do we end? But what makes the most sense?
So you touched on an important concept, and that is classification. So let's use you, for example. We got a trademark for you for DDMM Nutrition. You don't get that mark universally for all intents and purposes. We have a classification. So you have to pick a lane, and you pay a separate filing fee for each classification you seek. And you have to prove to the USPTO through photographic evidence that you are the first one using that mark in commerce in that class. So for you, we picked the classification for nutritional supplements. I didn't pick the classification for office furniture.
Right.
So if someone wants to come along and they want to manufacture desks, they can call themselves DDMM Nutrition, and we really can't take exception to that because there's no likelihood of consumer confusion.
Right.
So you have to pick the classification that best describes what you do. And then you have to submit photographic evidence showing that you're actually using the mark in that class. Now you can have multiple classes. You can have as many classes as you want. You're just paying $225 per.
And you have to explain what you mean. So you have to show them evidence of what? Explain that.
It's called a specimen. So for you, you have a product. So for products, you got to get a picture of the product itself, the packaging, the labeling, a sales display. And so we got some images of your product and your product's label, and I submitted that with the application. So what that did is it showed the name of your mark, and it showed it in the product as a whole, and there was some descriptive language there. So you can see that DDMM Nutrition is associated with nutritional supplements, and it's for sale.
Gotcha.
Whereas for services, let's say you're a coach. There's a lot of people in the coaching space right now. You're providing a service, not a product. So for services, your specimen would be promotional materials, a brochure, maybe a display at an expo. The most common kind of specimen I use for services is I just go to the website and I screenshot and crop the website.
Okay.
And that usually is sufficient as well.
Okay. All right. And how, I don't know, you've even been around this world for years now. How, is there any changes that you've seen now coming into 2020, 21, 22? Are there anything that people want to really look out for?
Well, regardless of the time, the main thing I would tell people is think about trademarks sooner than later.
Okay.
And so many people are being entrepreneurial now. I think there should be more of a sense of urgency that if there's a name that you really want, you want to lock it down. Okay. Sometimes people have an attitude of, well, I'm going to wait a couple years till I'm really in the black and I got some money and this thing's really churning out some money until I do this. I think that's erroneous thinking, because someone else might come around and hit you with a cease and desist. You might get sued for trademark infringement. And that's you want to lock down the name before you invest time and capital in building your brand and branding yourself. Do it at the outset. That's critical. Otherwise, if you're asking about like what's kind of new, there was a Supreme Court decision that came down earlier in the year. So the USPTO had regulations saying that anything that's obscene or offensive cannot be subject to trademark protection. Oh. And so somebody had a clothing label spelled FUCT. And the application was denied because they said, well, it's obscene. He appealed it to the Supreme Court, and the Supreme Court, I believe it was on First Amendment grounds, struck down the regulation and allowed the FUCT label to proceed. And so that's pretty profound law right there.
Are you surprised?
I can't say I'm surprised, but I was pleased to see it. Now, I'm sure a lot of people are going to want to push the envelope now.
Right. And I love that too. I'm agreement. I love that. And when you say pending, you have a bunch pending. What does that mean?
It means that the application is filed and they're going through the process. Okay. And it takes about 9 months for it to go from application to registration.
Okay.
So you spoke about timeliness. There's another thing. So here in California, all over the West Coast, it's a cannabis frontier out here. It's a cannabis free-for-all. But under federal law, it remains illegal. So let's say you're in the cannabis business. This came up in my office recently for someone who's in the industry, but they're not manufacturing or distributing cannabis itself. They have like a tangential service associated with it. And so I was curious, like, okay, well, could that get through the system or not? So I looked it up. And if you want to brand your cannabis product itself, you can't trademark that because it's illegal under federal law, and trademark is federal. Oh. But if you have a tangential service. Like what? Like a delivery? Utensils, paraphernalia, clothing. Oh. And so I'm working with someone who is interested in merchant processing for cannabis. Oh. So they're not selling cannabis itself; they're just serving the industry. You could trademark that, but you can't trademark the cannabis product itself. Gotcha. Huh. That's fascinating distinction there. It is. That's interesting because it is federal. Yeah. Right. It makes a lot of sense.
And and again, just so people are clear too, the pending, you get them to that point to where it's pending, then you get the alert on whether or not it's okay. Now, if it comes back, and I'm just, using very basic terminology here, but if it comes back and for some reason there's some hiccups, then what happens? Then you go back to your client, you say, okay, we need to tweak this, we need to tweak that. Is that what you do?
Right. So your trademark flew right through the system like a greased pig.
Man,
you flew right through.
I couldn't believe it.
Yeah. And sometimes that happens. In fact, I had one happen last year where I thought they were going to find a conflict, and hers flew right through with no problems. And then there are other times where I think, oh, this one's a no-brainer, and then we have hiccups. So that hiccup has a name. It's called an office action. So an office action is a denial by the USPTO of your application. And what they'll do is they will delineate the problems with your application. And so those problems can be curable or they might not be curable. It depends. So whenever I see an office action come through, and they come through frequently.
Oh, yeah?
It's not uncommon. I kind of roll my eyes like, okay, what now? All sorts of ticky-tack things could be an issue. So I just had one granted for a client where they wanted him to disclaim a word in his mark. So you could have blank, blank realty. Well, realty is descriptive. It's not distinctive. There's thousands of realtors out there. So you can't trademark the name realty. But if you have the name realty in your otherwise distinctive mark, you can have that trademark. You just have to disclaim exclusive rights to the word realty. That's an example of how a disclaimer works. So I had a client's mark just got approved. I got an office action where they wanted us to disclaim exclusive rights to part of the mark. So I just went in there, I checked the box, I submitted it. It took, 15 minutes of my time. And then within a week, we got a notice of publication. So all good. It's more problematic when they're saying that your specimen is insufficient. Your specimen really doesn't show that mark being used in commerce for that class. That's a little bit more problematic because now you got to go back and revisit your specimens. The worst one you can get is when they say, well, there's a conflict. So there's another mark that's before you that can result in consumer confusion. That's when you got an uphill battle because now you got to convince the USPTO to reverse itself.
Is there like an appeal process if they?
Yes. So what you do is you respond to the office action with some arguments and some legal authority, trying to get them to reverse themselves. Good luck with that because the same person who issued the office action is the one ruling on it.
Right.
So they're probably not going to be super keen to rule themselves. But then you can go through an appeals process.
Okay. And then is it a board of people that make these decisions, or is it individual kind of like of adjusters like that make?
I can't even speak to that because I haven't gone that far with any of mine yet, and I hope not to.
Okay.
Yeah. So
okay.
I don't want to even talk about a process that I haven't even gotten into yet. Okay. We haven't gotten that deep. Usually if, unless the client's got money to burn or they've already got a lot of money invested in that branding, usually it's wiser to reinvest your resources.
Okay.
So sometimes people just say, forget it. I don't even have a trademark. I'll just continue.
Okay.
Or I'll tell them you might want to revisit your branding.
Right. Tweak it and see if we can get it through.
So here's an important tool for people that a lot of people don't know this is available. So let's say you're contemplating, you haven't launched yet. Either you haven't launched your business or there's a product or service you're contemplating launching. There's a name that you want. Maybe it's a little suspect. And let's say maybe you're 3 months out until you're really ready to launch. But I'm worried someone's going to grab it in the meantime. There's a process called intent to use. So generally when you apply, you have to show that right now you are using it in commerce. For intent to use, you're saying, I'm not using it in commerce yet, but I intend to. So you file the intent to use, call it an ITU. It takes about 3 months and you'll get a ruling. And you'll get either an office action or you'll get a notice of allowance. And if you get a notice of allowance, then you have 6 months to submit a specimen. So really you have effectively 9 months to get your act together. In the meantime, you get your foot in the door, you start the process. So it's a powerful and useful tool. It costs a little bit more because there's a little bit more work, but that's something that people should know about. So if you're thinking about a brand name, you're not yet in business, but you're worried that, gosh, what if you lose your rights to it because someone else started doing it in the meantime? File an intent to use application.
Okay. All right. That and at least that gets some sort of protection and buys you some time.
And it's retroactive to the date you filed as well.
Oh, okay.
Yeah.
Okay.
Because the process does take 9 months.
So, okay. So at least there's some sort of peace of mind.
Yeah, absolutely. So I have a client who wanted to develop this brand. He's very big in his marketing. I looked it up. I saw a potential conflict. I figured it was different enough. The classification was different enough that I thought we could get through. We filed an intent to use, and the USPTO denied it. They issued an office action, and they said it's confusingly similar to this other person's class. And I disagreed with their decision, but my client, I don't know, spent maybe a little over $1,000 with me doing this process. Whereas had you went and built out this brand, you could have spent tens of thousands and then gotten denied later. So you're better off getting denied early before you invest time and capital in developing the branding and the infrastructure for that branding. Because if you get denied, now you're having to start over.
Yeah. And you already have customers and clients, and yeah, I mean, you're out there. Yeah, that's
so we're talking branding here. So let's say it's your business name. It's real easy to change the name of your business. I just file papers with the Secretary of State. We can change your name of your business. That's easy. Your website, your business cards, your logo, your Facebook page, your packaging. You're going to have to change everything if that name's not available, especially if there's someone else in the marketplace in a similar class. You don't want to find yourself getting a cease and desist. Yeah. So starting over with your branding, you're effectively starting over with your business.
Yeah, no, it's not, yeah, it's not good. And just so people know, it doesn't matter how big you are, that could come back and bite you. I remember way back in the day when the WWE was WWF, the Worldwide Wrestling Federation, and they actually they were fighting and they lost to, it's a WWF World, something with animals, and it's a huge organization, but they literally beat the WWE, and the WWE had to change to the WWE. Like, yeah.
Yeah, it's an existential threat to your business. Now, I remember a couple of years ago, you and we were kicking around different names for different ventures that you're involved in. You're a serial entrepreneur, so you're always dreaming and thinking about things. And there have been times where you and I are on the phone and I've got the test database on my phone and I'm telling you red light, green light on different things. But at least we're doing that at the outset before you go and sink a bunch of money on a brand. And I'm telling you, I wouldn't go there. Someone else already has that.
Right.
So you and I went through that several times.
Right. And the other big value that you bring that I want people to understand, especially small business owners, commission salespeople, or new entrepreneurs, feel like they need to do everything themselves, right? And at the end of the day, they don't realize that one of my mentors told me years ago, he says, when you bring the right people in that already know how to do that, right? You save yourself on what's called the dummy tax, right? Which is, and saves yourself time and money. So we're talking about things that you can actually save them time and money by letting you just handle it.
This is an important concept for business in general, about staying in your zone of genius and not trying to do everything. And I've been guilty of this myself. Why are you going to take the time to educate yourself on trademark law and the application, and then you're going to file it? You might screw it up. Then you're going to get hit with an office action. Then you got to deal with that. When you can pay a lawyer to deal with all that, and then you can put your energy and your time in your genius, generating revenue for your business and honing your craft. Why are you going to try to become a lawyer and do your own trademark? You don't need a lawyer to file for a trademark, but I strongly recommend it. In fact, one of the things I've got pending right now was for a gentleman who filed his own trademark screwed it up. He got hit with an office action. He tried to fix it. He made it worse. He got another office action. And this went through like 3 times.
Wow.
And finally, when we met each other, he was just at the end of his rope and just passed it on to me. So I substituted in as the attorney of record. It was like a giant knot I had to untie to figure out what are all the issues, how do I cure all of them. Got on the phone with the research attorney at the USPTO and untied the knot, got everything fixed. His mark is going to go through, but it ended up costing him 2 or 3 times what it should have cost him had he just done it with a lawyer at the outset, and a bunch of time and frustration.
Yes.
So I don't recommend that you do it yourself. You can do it yourself. Some people can get them through. I don't recommend it. Another critically important concept is who owns the mark. Sometimes people will put the mark ownership, because you have to designate the owner of the mark when you apply. They'll put it under their personal name. So I've got an LLC, but I made myself the owner of the trademark. Why would you do that? So I've seen it where lawyers filed applications for my clients' trademarks under their personal name. And then I come in later and I say, why do you own the mark personally and not your LLC? And the client says, I don't know. That's just how my lawyer did it. Now I've got a problem with that. And here's why. Let's say somebody down the road has a problem with that person's trademark. And they want to file a lawsuit. Or let's say someone's infringing on you and you want to go after them. Well, they can countersue you. So now your personal assets are exposed.
Your liability, yeah.
Yeah, because the owner of the mark is the one who's the party. So I don't care if you have an LLC. The LLC doesn't own this thing. The LLC doesn't have standing. So there is a procedure where you can transfer ownership of the mark from personal to the LLC. I've done that for 2 people in the last month, where the predecessor attorney filed it under them individually. And I was like, that's a liability for you. You don't want that. Let's move it under your LLC. That's why you have the LLC, to own your business assets, right? That's the point of it. Protect your personal assets.
Yeah.
Put everything under the LLC. So there is a procedure for doing that, but do it right at the outset. Put it under your company name.
Yeah. Just, again, right, always reverse engineer. Figure out your weaknesses, enhance them with the people and the systems so you can triple down on your strengths. Yeah,
absolutely. And I'm trying to do a better job about that myself. I'm bringing in some help because I'm doing things I don't need to be doing.
Right.
So I'm bringing in some help. And like, for example, like marketing. Why am I going to take the time to go and learn about Facebook ads and algorithm and demographics and targeting? I'd rather let a professional handle all that, and then I stay in my lane as a lawyer.
Well, 1,000%, because that and then if we're going to take the spiritual, throw some spiritual juice on that, is you're telling the universe you're ready to move on, you're ready to expand, you're ready to grow.
I'm experiencing that firsthand right now. I've made some big investments in my practice, scary investments. And there were 2 things on the day that I did them, big cases came to me. So yeah, I'm living it firsthand right now. And so it's kind of like the universe says, oh, okay, you're serious now. You're done screwing around playing small. Okay, here you go.
Yeah.
It's happened to me.
Yeah. Are you ready? Here you go. Yeah. And that's why we're here. That's why we're on this journey called life, man. It's all about that. Anything that I didn't touch on that you want to touch on before we jump off?
Oh, I can go on and on and on about Trademark. I just launched a YouTube channel a couple of months ago where I've been putting up some videos from a public talk that I gave, and I'm chopping it up in little 3-minute bits where I'm explaining the trademark process. There's a lot more to it. We just did like an eagle-eye view. So our objective here is just to educate people on what trademark is. And how the process functions. One thing that's critical, it's important, is that a lot of people, they transpose trademark and copyright. They use it interchangeably, and those are different vehicles, different government agencies, different statutory schemes.
Good.
They're both under the umbrella of intellectual property, but they're different animals entirely.
So you do both?
Yes, I could do both. In fact, I filed 2 copyright registrations last night.
Okay.
So trademark is for branding. It's for the name of your business, the name of your product or service, or for your artwork, or for your tagline. It's your branding. Copyright is for content.
Okay.
So I filed copyright last night for someone's artwork and a separate copyright for a book that he wrote. That's content. Now, if you want to, let's say you're a band, you're Pearl Jam. You can trademark the name Pearl Jam, but the individual songs will be copyrighted.
Oh, okay. Okay.
And let's say you're writing a series, a book series. You trademark the name of the series, but the books themselves are copyrighted.
The content. Yep.
Yes.
Gotcha. And you handle both of those. Good.
Correct.
That's all, and that's great to know. And yeah, like you said, we're here to do this episode to give somebody that 30,000-foot view, and also just as important for people to understand that there's resources out there, right? There's resources out there. There's people out there. There's companies out there that you should be leveraging, right, to make sure that you're doing it right.
Well, so I have another message here. So I assume that some of your audience are people who are actually in the marketing and branding space, professionals in that industry. I would think that's some of the people who are watching this. So for if you are a branding or a marketing professional, this is subject matter that you absolutely need to know. Because if you're going to take a client of yours and you're going to put them in the driver's seat of a company where the name is not really available, you're buying your client a lawsuit down the road, or potentially the client having to start over down the road. So if you really want to be a professional person in the marketing space or the branding space, you need to know what the test database is, how to look it up. I don't advise you to start practicing law, but this is subject matter that you need to be familiar with. And I would recommend that you have an intellectual property lawyer in your pocket that you can send people off to.
Yeah, absolutely.
I think it's irresponsible to put someone in that car and then push them off a cliff.
Great point. That's a great point. Yeah, I love that you did talk about that. So what we're going to do is Tom's going to give us all his links where you can find them. We're going to put them in the notes. And anybody that's getting any value from this, please share it, get it out there. You can find us on every single platform known to man, just about, for podcast and our YouTube channel. So, and if you're getting value, please jump on and subscribe to both of our YouTube channels and help us get it out there, because this is real world content, man. This is real world practical information that people need to cover themselves. Love it. And want to thank you for taking the time, man. I know you're pretty busy, a lot of balls in the air, as always, but yeah, so we're going to, again, guys, thanks so much. And if you get any value from this, please share it out there, and we will see you on the next episode.